Welcome back. You're watching NewsX and I'm Shivani Singh. The latest news that we are tracking for you comes in from the courtroom, where the Supreme Court today paused the implementation of the University Grants Commission's new anti-discrimination rules, citing concerns over their vague provisions and potential misuse, taking note of the non-inclusive definition of caste-based discrimination and excluding certain categories from protection. The court issued a notice to the government and the UGC as well. The controversial regulations will remain on hold until further notice. The UGC notified the new regulations earlier this month, making it mandatory for all higher education institutions to constitute equity committees to look into complaints of discrimination and to promote inclusion. The rules require the committee to include members from the other backward classes, scheduled castes, scheduled tribes, persons with disabilities and women. The rules exclude general category students from complaining under its grievance redressal mechanism, and for this reason the rules have been legally challenged and have triggered protests by students in several states. Joining us on the broadcast live is Advocate Ashwini Dubey, AOR, Supreme Court. Thank you so much, sir, for joining us on the broadcast. We appreciate your time. Sir, when we are looking at this entire case, obviously we have seen how this is a very big judgment that is coming in from the Supreme Court. It's stating clearly that the provisions are vague and they might be misused by certain parties.
Yes, see, the first observation, oral observation of Honorable Supreme Court is that are we going backwards from whatever we gained in terms of achieving a casteless society to the vague definition which has been given in Rule 3, Sub-Rule C of the UGC regulations. Number 3, it was only, as you said, it was only allowing one part of the student, one section of the student to be the victim side and one set of the students to be from the operational sides, the offender side. See, when the Constitution says that nobody would be discriminated on the ground of race, caste, sex, equality is the paramount and sacrosanct, and also the inherent feature of the Constitution that equality was being shackled. For the universities and higher education institutions are the place where the academic excellence has to be seen irrespective of the caste. And here, moment a student from a deprived community, which I today would call, keeping in view the 2026 community, the general community, would go to the university, he would have to first be offended by an act that he has to lower down his voice even for the academic things. Otherwise, a certain section of the people will implicate him. Fourth and fifth, the law which would support a particular section and which would be against the particular section, that was the vague, contrary to the Constitution's object and also contrary to the academic excellence for which the University Grant Commission Act 1956 was implemented. Here, if amendment or any regulation is brought to bring the uniformity, that would always be welcome, because in universities and colleges and schools we bring the uniformity, uniform education, the education which is capable of enhancing the personality, productivity, and also which develops the overall personality so that you can compete in the world. Here, on the other hand, you were being discriminated on the ground of caste. That was the reason 3C, which was arbitrary, exclusionary, discriminatory, ultra vires the Constitution of India, and that is why, which was destructive of very object of promoting equity in higher education. So Honorable Supreme Court in its wisdom very candidly and very rightly has pointed out that on the one hand we talk about the casteless society, then on the contrary, if we bring this kind of law, these regulations and law will be contrary to bringing equity, inclusion, and that will not be discrimination free. So it's a welcoming step of Honorable Supreme Court.
In fact, sir, some of the statements that came out from the Supreme Court, they've mentioned that unity has to be maintained. even in our educational institutions, you cannot, like you've mentioned, one of the biggest statement is if you are moving towards a casteless society, how can we base the entire regulation on something like caste? So they have said that unity is of utmost importance, that must be reflected in our educational institutions as well. And the Supreme Court has also in fact stated that there has to be a remedy for everyone, because the victims cannot be left remediless. They haven't spoken about ragging, that has not been included in the new regulations. They haven't spoken about cultural discrimination. That is something that the CJI also raised during the entire argument, sir.
Yes. The Honorable CJI have very categorically said that the discrimination which you are finding and saying that one community, one class would be discriminated and one would be the oppressor. So that is, this is very important thing which is to be looked into, that too when you are talking about eradicating discrimination. We are talking about the preamble's commitment to eradicate discrimination on the ground of caste, by removing the caste system, and promoting the full equity and inclusion in consonance with the national education policy. Then bringing this legislation, regulation 3, subclause 3, which defines the caste-based discrimination, that is of course a point where the other section of the students will be in a vulnerable position. Now, the narrowly confined manner of discrimination only on the basis of caste or tribe against the members of the scheduled caste, scheduled tribe, other backward castes, the design and operation and the definition accords a legal recognition of victimhood exclusively to certain reserved categories and categorically excludes the persons belonging to the general or upper caste from its protective ambit, regardless of nature, gravity, and context of discrimination suffered by them. Now, let's take an example. Supposingly, if any student from general category is victimized, where will he go? The first test in universities first investigation has to be looked into by a committee. Then who would be the committee members? Those committee members will exclusively act in accordance with the law. They cannot take any decision which is contrary to the law. Why I say two things I would say. One, if you see the SC Commission, can you, Shivani, elaborate a single complaint from the date of inception or the establishment of the SC Commission that a single complaint was found to be fake, and SC Commission has openly come and said that, look, this person belonging to the SC community has misused this position and have filed a vague complaint? Number one. The same goes with the ST Commission. So if those commissions which were established in order to support the SC and ST couldn't dare to say that one SC community has misused this position and filed a vague complaint. So can you imagine that in universities or the colleges which are known for the academic excellence and inclusion, uniformity, and when the committee would be supportive to those who are protected by the law, would come and say, no, this complaint is found to be vague. Now, other example. Here, there is an appellate system in court. Supposingly, if one complaint is found to be vague, one student studies in a university either 3 years or 5 years, if graduation and up to post-graduation. After a redressal of a case, even in courts take maximum 10 to 15 years. Supposingly, wrongly, maliciously, mischievously, one case is filed against a student of general category, he will have to suffer that, and that will take 5 to 10 years to get rid of that, and then it will be noted as a criminal antecedent against him. He would not be entitled to get a job of even teacher and patwari. You forget about the IAS, IPS or professor or any other higher post, because that would come. Is there any criminal case pending against you? He will have to write yes, and moment he writes it, he would be excluded from the defense forces. He would be excluded from the armed forces, paramilitary forces, uniform forces. He will not get the job because there is a criminal case pending against you. Number two, if he honorably acquitted from that case, after 15 years, what would be his age? He would cross the age. Now, if he start action against the person who has instituted a wrong case, again that will go for 15 to 20 years. And after 20 years, then appellate system of the country, it will go up to the Supreme Court. So his whole life would be destroyed by fighting a case which he never committed. So where is the balance and proximate link to ensure that one section is not implicated in a false case? And that was the motive Honorable CJI in its wisdom, in its vision, have seen it, that yes, this may happen. And Honorable Supreme Court very rightly said that the definition is very narrow.
Right.
And regulations have to be kept in abeyance.
Right.
Yes.
All right. Thank you so much, sir, for joining us on the broadcast and explaining that subject in detail.